I recently read somewhere, I think it was possibly it was in the American Journal of Psychiatry, that most psychiatrists these days are women, females. Is that true?
I think it's turning more feminine, the classes.
Because it used to be a low number, you know, a very low number. But it's gotten much more. When I came through, I think went through the program, there might have been one female, maybe 7 or 8 males, but things have changed. All right, so I mentioned that this case is going to be coming out of England, so we don't know when it's on, right, Roberto?
No.
It's going to air there, and then they'll air it over here, sort of see what happens. Now, this is part 2. So last time, a couple people missed, I went through just the general background of workers' comp. And today I'm going to really focus on the interesting issues, and to show you, it's a real legal system. There's an internal workers' comp appeals board in San Francisco, which is commissioners, and then it can go outside that. I'm not even sure what the technicalities are that get it outside the workers' comp system into the appellate court. But the first case I want to discuss, and it's with all your practice, actually, and this is about, and I can ask you that too, first of all, before I give you my opinion. What about a third party sitting in on the visit? Let's say it's a boyfriend, let's say it's a husband, let's say it's a parent if it's somewhat younger. What's your theory about that? Any of you, what's your idea? Of course, you're going to need it, like I say, interpreters. If you need it, you need it with an interpreter.
You make it a biased view, or they may not give all the information that you're requesting of them if they have, say, their mother sitting with them or their boyfriend.
Well, that's true. You might not get the straightforward picture. Same
I really like it because I mean they might also get information from the other party.
They'll let that too. Yeah. Now, what if somebody shows up? Let's say possibly he's looking. Do you ever see some? You see some criminals out on bail sometimes, right? Mm-hmm. Let's say a guy shows up with his defense attorney, and the defense attorney demands to come in and sit in. What do you say? How do you handle it?
I wouldn't do it. I actually had an attorney that wanted me to let him know when I was going to be a defendant to tag team with me, and I told him that I don't do that.
Yeah.
So.
But this is the case you can quote, by the way. I know the first page was blank, but it's Vinson versus the Superior Court. We'll get into that in just a second. And I had to quote that to a lawyer once who showed up in my waiting room wanting to sit in on a personal injury evaluation, and I said no. He got very angry, and then I had to quote this case, and this case quotes other cases. I'll go through that in a second. But regarding a third-party attendance at an examination, obviously interpreters can be present, should be present. As far as family members go, I will frequently bring them in at a later stage, whether it's criminal or civil. But I agree with you, they shouldn't come in initially. No way. And I remember once a guy that I recently saw, I just thought of that. I said, your wife is out there. She wanted to come in. But is there any problems you're having with her before I bring her in, before I even speak to her? He said, yeah, I can't stand her. Because, no, it was a serious thing. He said, because a few years ago, she took our kid to a Christmas party, and our little 2-year-old drowned. And he blamed her for not paying attention. He didn't go to the party. He became an alcoholic and really screwed his life up. So knowing that, I wanted to know that before. But I said, well, can I still bring her in for a few minutes? And he said, okay. But if you do bring a third person in, you should always know what's going on between the two, like that case. That case I always think about, wow, he holds her responsible for their child's death. And I've been cross-examined a lot. And if you bring a family member in early, you're going to be attacked. Well, her mother was coaching him, or his wife was coaching him. And how do you know that wasn't happening? So it's better to bring them in, but later. Not officially. If they demand to come in, the third person, you can say no, but you can't say that we're going to proceed with the examination. If they said, well, your other option is, well, it's not going to happen. We'll have to work it out with the lawyers. But you do not have to let a third person in. And workers' comp, this is interesting, though. In workers' comp, attorneys don't show up because they don't want to spend their time. But they can have a representative show up at any examination but psych. Most attorneys don't even know that. But if you have this case, this Vinson case, to quote to them, and the site is up there from the Supreme Court, so they can sit in during an orthopedic exam. they're not supposed to tape record it, but whether they put a digital recorder in their pocket, you don't have any way of knowing. It's illegal to do it. They can take notes. Doctors sometimes, we're accused of it a lot. Probably happens. To see the person for 15, 20 minutes, you say you saw them for 2 hours. You don't do it. I don't do it, but some people do it. So that can happen. But from a psychiatric point of view, can't do it. And if he's just coming in to witness what's going on, it's not permitted. And there's some interesting quotes in this case here, this Vinson case, V-I-N-S-O-N. This went to the California Supreme Court in 1987. It was somebody who, it was a defense exam actually too. And they said even though it's a defense exam of a woman who is alleging sexual harassment, she still does not have the right to have her attorney come in.
Dr. Stalberg, sorry.
Yeah, go ahead. No, anytime you have a question, please.
That was Vincent versus what? I didn't see
No,
that.
one of the blank pages, it has it at the top. It didn't copy out.
Oh, I don't think I have it.
You don't have a copy?
Yeah, Vincent versus Superior Court, yeah. We do.
Vincent, V-I-N-S-O-N versus Superior Court. That's a good case to read because you might want to, it's nice to have that to quote to attorneys. Now, I didn't show my background or resume to the two new students here, but I'm going
That's just workers' comp.
No,
It's not.
any, including criminal, including child custody, including whatever you think.
Okay.
It is. Whatever you think is a psychiatric examination. Now, can they go to court? If they think, especially a male, if they think he's got a history of harassing women that he examines, and they can show that and convince a judge, then maybe with a court order they can get an order to bring in a tape recorder. And I've had one examination, believe it or not, videotaped. The tape was on, I didn't really have any control over it. It was ordered. Actually, the defense agreed to it. I got stuck. It was too late for me to cancel. But and they commented on a prior case called Edwards, which was in the 70s, and they said, well, if the legislature didn't like our opinion in 74, they haven't done anything in the last 13 years, so this is the law still. It's called Vinson, V-I-N-S-O-N, and let me read an interesting paragraph from that. This is what it says right in the Vinson case, V-I-N-S-O-N. Whatever comfort attorneys' hand-holding might afford is outweighed by the distraction and disruption of a third person. So even the court, as liberal as they were at that time, realized that a third person just gets in the way of a psychiatric exam. Now let me ask you this. It gets in the way of, if you can develop rapport, it interferes with it. It sets up more of an adversarial situation and just general interference. I got a call a couple months ago asking me if I would allow a court reporter in to report the psychiatric examinations, psychiatric visit. What do you think of that?
I would say no.
I said no as well. And I've even had court reporters. I was talking to a court reporter last week, and he said he's been asked to do it and refused to do it. He doesn't think it's his role. You think court reporters should come in on a psych visit and run it like a deposition, saying, wait a minute, one at a time, and blah, I didn't get. It would create a chaotic. But once a psychiatrist or two starts to let it happen, and they testify or they write that it didn't interfere, it might open the door. It doesn't take much to open this little door, So I think we should keep them. My point of view is we should keep them out. But that's nice there about the hand holding that the Vincent case holds. They just, and really, they went on and on and on about it. Sexual harassment, it's a male psychiatrist and a female patient. But they said, well, you have other things you can do. You can go get a court order to allow you to tape it. I assume it carried to an extreme. They would have allowed somebody in there to videotape it. But it never happened. And this is still good law. This is the law as of '87. So here's the full case if anybody wants to take a peek at it while I go on. But that's the issue of the third parties coming in. That's just general, and that's a very good question. Was that workers' comp? Because although I'm talking about workers' comp generally, that just holds for every third-party exam, every medical examination, really. And the court, a lot of times I don't agree with judges, like most of us, and we don't agree with judges, but I think they saw that one correctly when they said, you guys can, all the doctors have to let a third party in except psychiatrists. You guys don't have to. And I think they reasoned it out pretty well. And that says it all right there. Whatever comfort attorney's handholding might afford is outweighed by the distraction and disruption of a third person. Now, the litigation privilege. I have a sheet on that. Interestingly enough, the one I found when I'm looking through my collection was not certified for publication. So, but I'm still that. But that's still the law. And what that means is this. And there's an interesting. Which case was that? You have it there somewhere. Yeah, it was this De Los Reyes. I'll give it. They also say not to be published. But the reason I gave it to you was it'll cite other cases. And what it basically said is that the litigation privilege. So what this man De Los Reyes did here, and you might say, well, it's not to be cited, it's not to be published, but it's still the law. And I don't know why they said not to be cited. I don't understand that. But what he did was he sued the doctor who performed the examination. He sued him for, I don't remember what he sued him for. He just sued him for, some kind of contractual problem. Perhaps the doctor accused him of malingering, and he sued the doctor for slander and defamation. And if this is something very important when you're out there in private practice, if there's a judge in the case, like a workers' comp case, personal injury case, mental health where the guy has an attorney, right? Community property or a family law, there's a judge, so if you say so-and-so be an incompetent father because he drinks, he can't turn around and sue you because you're protected by judicial immunity. But there's an interesting and there's an important thing that you have to keep in mind. Personal disability, like the Aflac stuff that they advertise on TV, if that guy's applying for disability and he doesn't have an attorney yet, and I know this happened to a doctor actually went through this program, he called the guy a malingerer. The guy sued him for defamation, slander, for millions of dollars, and his malpractice carrier said, it's not your patient, we're not going to cover it. The insurance company said, you're not working for us, we're not going to cover it, and this made this guy's life a nightmare. So I won't tell you not to do it, I wouldn't advise not to do it, but I would say be very careful if you examine anybody for a permanent disability, not permanent, temporary or permanent, personal disability plan, and there's no attorneys yet involved. In other words, Joe Smith has filed a claim with Hartford that he wants, or UNUM, he wanted permanent disability, temporary, he wanted disability. And he does not have an attorney, and the insurance company doesn't have an attorney, and some agent calls you up and says, will you examine Joe Smith for me? And if you do it, and you do something that he doesn't like, and he sues you, you might be stuck where you have to pay everything to defend it. Because the insurance company will back off and say, oh no, that doctor wasn't working for us. And any insurance company that you may have might say, oh, we're not insuring for this. So did any of you hear that could be a problem? Because I know we've met with Tim and other doctors, and we were warned to be very careful. And we met with attorneys for these companies, and they won't insure the doctors. So you've got to be very careful with what you write, not to the extent where you won't write what you can back up, but you could get sued, and they won't pay for any legal defense. So these cases that I mentioned here, the Harris case, the Wiggins case, and this De Los Reyes here. Truth-seeking proceedings is interesting because truth-seeking also could be just doctors examining. But I think what they mean by that quote there is that there's a judge involved that's already been assigned to some judge in some court, or at least there's some attorneys involved. So therefore, you get the advantage of judicial, with so-called, maybe you haven't heard about it, judicial immunity. Have you heard of judicial immunity?
No.
That's what it is. When you give an opinion in mental health court, you're not going to be sued by the guy you say should, it's 5150 or needs a conservator and should be put in the hospital. You could be sued by him, but it could easily be dismissed.
So I guess I don't understand what the difference is. If you're doing it in that case versus in this case, or say, like you said, an insurance company for disability, how is it sort of different?
Okay, exactly. Okay, let's say that Joe Smith, Joe Citizen, gets hurt and he hurts his leg, and then he files a disability claim for his leg, and then he files a claim for depression. And he doesn't yet need an attorney because Unum or Prudential, somebody's paying him a couple of grand a month. Then you examine him, he claims now he's got depression, suffers depression. Then you see him and you say, it's not that bad, he can work, or I think based on my mental status and based on everything that I have, I think he's exaggerating substantially. You might call him a malingerer, you might call him dishonest, whatever you might, just from putting all the records together. There's no attorneys yet involved in the case, and you're a sitting duck for him to sue you. Now, is he going to win? No, maybe not. But the point is you may have to defend yourself. The reason is there's no judicial immunity because there's no judges. There's no attorneys involved yet.
But if there was an attorney involved in his case, and say that attorney called you and said, can you evaluate my client? And say you decided to do so.
I think that would, when he gets an attorney, as far as I'm concerned, he started litigation. I think you'd be covered. But his attorney's never going to sue you. Just go get another doctor, right? Oh, I don't like what she said. I'll go to another guy, see what he says. So they can
kind
do.
of like an unrelated question.
Yeah, go ahead.
But in that particular case, if there's no litigation privilege because there's no judges involved, involved at that time, it's almost like a patient-doctor relationship in some cases. So how could that be defamation if they're just coming to you and you're saying, well, I think that you're malingering, because you're not defaming them, you're not telling anybody, in the world that they're malingering, you're just telling that one person who's coming to you for an opinion.
But let's assuming though you're giving the opinion out. Let's say it's an insurance company exam, so-called defense exam, and the claims examiner from Hartford, Connecticut somewhere, or wherever it may be, Unum, I don't know where they're located, Chicago, whatever, they call you up and you set the exam. There's no attorneys yet involved. There's no real litigation yet. And I think anyway, the courts have held, and they did in this case, I know this fellow caught it. He caught the case. I mean, he got a lot of, not trouble, financial problems and legal problems, and he got caught in a gray area in the middle. And you made a good point. If he has an attorney, I think, though, if it's pursuant to a legal, an attorney beyond a claims examiner, they've set up the exam, I don't think, you can be sued still for anything, but let's say the defense, well, to see if the defense attorney has set up the exam, you're asking good questions. The defense attorney sets up the exam, I think almost by definition there's already litigation going. Basically what I'm saying is a pre-litigation, it does not apply if litigation has not started. That's, and I have to look at those cases again, but I think that's what it is. Truth-seeking proceedings. Truth-seeking only means, for some reason, judges are in charge of truth-seeking when you're in court. But if an attorney sends privately, look, I've been sued for battery by somebody in Riverside claiming that I break into his house every morning at 2 in the morning and beat him up. And he took out a restraining order against me. He was crazy. He was psychotic. But I had to go deal with it. I had to send an attorney. I had to spend a few grand to go tell the judge. Because if you don't show up with a restraining order, it's granted. You've got to show up. So I showed up, and the attorney showed up and said, no, he saw that guy a few years ago. He saw that doctor a few years ago who put him in the hospital. And the judge says, okay, and he didn't award the restraining order. But you can be sued really for anything. That's the problem. The point is where you have a lot of, the word is exposure, right? Gee, is anybody going to defend me? And the insurance company that hires you won't defend you, and your own insurance company, if you have one, is claiming it's not a patient, because that's another interesting issue you raise. Is there a doctor-patient relationship when you evaluate somebody? Let's say for work comp, or when you go down to county jail on a 10/17 appointment?
My understanding is there isn't, but you have to make sure that that's clearly understood. So you say that when you start your evaluation.
You should. But what if you don't say? What if you forget to say it? If you forget to say it,
I still think there isn't.
there's not a doctor-patient. I don't think there's a doctor-patient relationship. Does anybody here think there is? When you see somebody for a court order, I don't like. I'd like to think like that case that coming over from England put me on television for that gentleman, that deceased murderer. It's never my patient. But it's a gray area, and it's,
Yeah, but
it
I mean,
can
if
be argued.
someone's coming to you, there's no lawyers involved, they're just coming to you saying,
Right.
can you tell me if this is, it's almost like a doctor-patient relationship, because there's no court order, there's no lawyers involved, there's no judges involved, you know, it's just a patient coming to a doctor asking for an opinion. So in that case, that could be considered a doctor-patient.
But you're saying with a 7:30 email, right?
Well, but getting back to this,
separate thing.
but why could, this is argumentative from the point of view, we can argue, and I don't know the answer to it. If you called your patient a malingerer, could he sue you? I think he could.
He could.
But it has to be, it has to show that you said it outside of the to somebody else, right? If you just say it to him, I mean, you're not defaming him, you're just telling him your.
Oh, you're right, if you're just telling him, but if you write it in a report and it gets out to somebody, yeah, then it'll be defamation. Could be. Theoretically, it's defamation, you know? That's why some doctors are reluctant to say malingering or exaggeration, you know.
What if you have it in
Good
your
medical
medical
record.
records and then that gets released for a report?
I mean, they have to show that's not true too, right? Because if it is true, then it's not defamation,
That's a complete,
it's actual truth.
the complete defense to defamation is the truth, that's correct. But it's hard in our field particularly to prove malingering, right, or prove substantial exaggeration. We can do it, but it's hard. The point is you don't want to get caught up in a lawsuit. That's why I say the doctor got caught. And this guy, by the way, who sued him for slander, he was like on a board of directors of a big corporation, and we're talking like probably $10,000 minimum a month in private disability that he was lost because of this doctor. So you know what generates a lot of lawsuits? The A word, anger. The guy was angry at him. He was annoyed, very much so, more than annoyed. This doctor cost him $10,000 a month, more. So he figured he went out to get an attorney, and the attorney said, aha, we'll get him on this malingering. Well, we'll sue him for defamation and slander. And it went to a big lawsuit, went into federal court, and got into federal court because the patient or the alleged disabled person was in this state, the insurance company is in another state. So that's, you know, there's two different forums, two different places where the lawsuit could happen. So that would be dangerous. Well, anyway, I can just tell you, when I was at that meeting, Tim was at the meeting, a couple of them, insurance company tried to show up and tried to say we should still do these evaluations. But they said they wouldn't insure us and they wouldn't protect us. But they gave some kind of fuzzy reason why we didn't have to worry. But yeah, from what this one guy said, I know it cost him a couple $100,000 and it made him a nervous wreck for a couple of years where he was potentially going to be sued for a few million, you know, and lose if he had lost. So that's, but what you tell your patient is another thing. But they can always go to another doctor if they don't like what you say, right? And if it's between you and him, I'll write your private report and you charge him X amount or do whatever you do, write a little summary or you tell him to his face or her to her face. And if they don't like it, you know, you'd hope they just go elsewhere. Oh, you can't help me get on disability, doc? You can't help me? It's unlikely that they would sue you. But you know, this Bradley guy in Riverside who tried to get a restraining order, I was shocked when I saw it, and I called an attorney. This might have been 15 years ago. Bradley Carter, that was his name. And I said, what's going on with the restraining order? This guy's claiming I commit battery on him every night at 2 a.m. And it was laughable. He laughed. He says, you know, you got to go out there and fight it, otherwise you get a restraining order slapped on you, and then what will the medical board say if we get a restraining order against us for committing battery on an ex-patient? So I had to fight it. Huh?
Every day at 2 a.m.
Yeah, every morning at 2 a.m. I mean, the judge knew it was laughable, but the point was I had to show up.
Yeah.
So that was that. So this is a complicated issue, though, and I'm going to say, having gone through residency here, the fellowship, forensic boards, I'm an attorney as well. I didn't put my resume up for a couple people new today. I didn't know the answer to this, and I didn't know the mess you could get into for these sort of evaluations. I feel like more comfortable. And in fact, even now, sometimes you'll get somebody who doesn't have a lawyer, they're pro per, but there's an insurance company attorney, and there's a case number. That's the key. You want a case number. You want a claim number. And more than just a claim number sometimes, but you like a case number from the court. And but even then, when you get a pro per injured worker or pro per plaintiff, if any of you have pro per criminals that you've dealt with?
No, we're still in training. So.
Huh?
And we're still in training, so not
Yeah,
really.
pro per
Nobody.
plaintiff, and they're tough to deal with because you say, well, I can't talk to you, I'm an agreed medical doctor, or I'm in the middle, and they'll say, wait a minute, but I'm also the guy with the lawsuit too, so he's both. So it's difficult. Plus, judges hate it too because these guys don't know the law. It's a difficult situation. But they're the two cases, and I should get you the sites on them. I don't have it. Harris and Wiggins. I have them somewhere. I'll get them to you. By the way, somebody perhaps who was here last time, I got a call, I think within a few days, that somebody wanted to come out and sit in on one of my depositions. Was it either of you two ladies?
No, but could we?
Yeah. Yeah, the answer is yes. I don't have any more cards. I know I gave a bunch out last time. Do you have any, Roberto?
Well, I have my card, so I can always give them one of mine, and then they can email me, and I'll...
All right, we'll take care of that later.
So in past.
Oh, I do have a couple, I'm sorry.
Some people have been a little bit leery of letting us sit in on depositions, saying that there's a chance.
So I'll give you two people that weren't here before. Yeah.
Saying that we could then get subpoenaed for that particular case.
Well.
Is that something that you?
Well, wait a minute. The message I got was a deposition, but deposition is where I'd be testifying about some report that I've written about an injured worker, right? Actually, the perfect way to do it would be sit in on an examination and go in order, you know, and then, oh, this is what he does, this is how he does it. And then if you wait it around, unfortunately, the workers' comp system is so slow that they won't get around to taking my deposition for 6 months. So that you probably should do that. The way my schedule's set up, depositions I do at 8 o'clock, cases at a little bit later. So you'd sit on a depo on a different case, but at least you could see what goes on. Now, as far as being, no, sitting in on a deposition, you're just like sitting in the court watching testimony. You're not going to be subpoenaed to anything. You'll be identified because you have to identify everybody in the room. But you see how depositions go. And then as far as sitting in on a visit or an examination, you could be subpoenaed. That's the problem. From your point of view, it would be a problem. But I think, to me, you know, when I went through the program here, you all know about the heritage of the late Dr. Pollack. It was fun going down to court watching him testify and duel with the prosecutors and the defense attorneys and the judges, and, you know, intellectually duel with them, because that's really what it is. You know, but anytime anyone you want to come out, I'm located in Santa Monica. That's where I do them. And I probably have depositions, because I'll get to that it's a good question. Most of the time, as I said last time, I'm an agreed medical examiner. Now, you weren't here last time. Do you know what that is? You?
What was that?
Agreed, A-G-R-E-E-D, A-M-E.
No.
That means both sides agreed. Workers' comp has a lot of negatives about it. One of the good things is there's no juries, so you don't have that problem. You just have to talk to a judge, and then guess what? They don't even let doctors go to court. Everything is by way of report and by way of deposition. So that's what makes that stuff really important. An agreed medical examiner means, let's see if I have that coming up. That's the Power case, yeah. If you see the Power case, again, that's blank. I saw it in the beginning. But that was another Court of Appeals case in 1986. And that fits right in with what I was saying. And it's an interesting name for the case, because that tells you why. And it makes sense when you think about it. An agreed medical examiner has so much power in workers' comp. And the reason we do is because the insurance company didn't go out and hire you because they know you don't, you know, you're very conservative, or you don't like to give opinions that help an injured worker. And then the injured worker's attorney doesn't go out and hire you because you're too biased in favor of the worker. Yeah, I'd probably put it on the same page because they're just blank.
So is that the same as, I have friends that during residency were doing workers' comp evaluations as moonlighting jobs. How is that different or similar? Or what is that even? And I would think that kind of opens you up to a lot of...
There's some problems there.
Yeah.
And they're probably working for other doctors, right? I'm not asking for names.
Yeah, I'm not sure.
Yeah.
But I know that
right.
they go on a Saturday or Sunday,
right.
and there's so many cases lined up for them.
Yeah. Well, I mentioned it last time. The state law says psychiatrists have to spend an hour. I don't think that's nearly enough when you're seeing somebody 50 years old, and you got to ask about every injury and every problem they've had in their life up to and including the present date.
They're supposed to spend an hour? Because some of them
Here we go,
don't
see?
spend an hour.
Yeah, I know. See, that's why I said that. But psych, at least the legislature has, I'll say it, I don't care who hears me, half a brain, right? They realize that psychiatric examinations take longer. So our minimum is 1 hour. My minimum, I said, is 3. And I think I saw somebody last week for 3, and I'm still not done, and I think I saw 3 before that. And I guess it's very complicated.
Yeah.
A very delusional lady with very complicated, and do I know if it's work-related or not? Well, I got to figure it out. And it's very tough, and some of these compulsive, delusional individuals, especially with delusional disorder, can produce monumental amount of documents once you read them and so on. But as far as the residency, that's an interesting point. Now, if I recollect correctly, I couldn't get my boards until I was 1 year out of the residencies. It's still time in just general psych, American Board of Psych and Neurology, right? 1 year.
Yeah, about that, maybe like 6 months.
So right now, this person, not right now, but this person, when he was doing the exams, if it was during his residency, he actually wouldn't have even been a psychiatrist because he wouldn't have completed the residency, right? Mm-hmm. So he wouldn't have been a psychiatrist, number one. Number two, he couldn't possibly have had his boards. Mm. I would consider that an invalid examination, but probably somebody was co-signing it for him.
I'm not sure. Yeah.
I don't think it would be valid. Now, there's this thing that started, I mentioned this last time, qualified medical evaluator. As of 1994, you needed to have completed a residency and actually had your boards, except the first time, the old grandfather clause, the guys who hadn't passed their boards, they allowed it once. Now you need actually to be board certified in psychiatry to do these exams. Now, psychologists, what's their role? Because the labor code says psychologists are physicians, they are. You've got to deal with them. That's it. That's interesting. You have a very interesting question. I think I mentioned this last time too. Psychiatrists can't use historians. We can't have somebody sit there take a history. Like orthopedic surgeons can have a secretary come out. How old are you? How many brothers and sisters do you have? Could you explain how you got hurt? Could you explain everything? And then they go and give that to the doctor, and he rushes through the exam. And the minimum, by the way, the state set for the first visit only. If you could believe you could do a complete exam, I think the minimum for orthopedic is 20 minutes. How could you do a big, complicated orthopedic and take a history with somebody who's had a failed back surgery, a fusion, and got a bad neck, and carpal tunnels thrown in, and some unrelated traffic accidents and surgeries? And this doctor is going to go through everything in 20 minutes? I don't think so. But go ahead.
Sorry.
No, go ahead.
Sorry, I'm asking something.
No, that's all right. I enjoy the questions.
So in, I don't know if I should say the name, but in a certain medical company, they use nurse practitioners to do the initial evaluations, and then the psychiatrists do like a follow-up evaluation.
Now, please don't give me the name because it's being videoed.
So that's not, because this is a big company that they.
Well, that's unfortunately.
So that's not supposed to be the case.
That might be what we used to call a mill, right? M-I-L-L. Seeing a lot of people, crowded waiting rooms or factories. A nurse practitioner is not supposed. A nurse is not defined in the labor code. It's as silly as it is defining, chiropractors as physicians and psychologists as physicians and podiatrists as physicians. Nurses are not defined as physicians, so I don't know. But what the doctor would probably say in his defense, I'm not trying to read his mind, he's probably going to say, well, that was my historian, and she's got some training. You're not supposed to use historians at all, though, in psychiatry. So that doctor would have a little trouble if he or she had to support the report. By the way, there was pending legislation last year, I know a little more about it now, to have no compensable, let me go back, to have no psychiatric claims in workers' comp in the whole state of California, going forward from last Tuesday. As of January 1st, 2013, there was pending legislation, no psychiatric claims, either stressed out, became psychotic, or you got a failed back, and on top of that, then you got a heart attack, and you're so depressed now you're, need all this help and everything, and you become psychiatrically disabled. That didn't make it. Do you think that would be fair to have no psychiatric claims, period? None of us think so. What has passed, and it's the law now, how much of it's constitutional, how much of it's going to stand up, and nobody knows because it just started, is no so-called compensable consequences. Do you know what that means? If you have if you have a physical injury at work, hurt your back, then you have surgery, can't work, lose your house, lose your kids, lose your wife, whatever, then you get depressed, too bad. You can't collect, or I can't get the help for the depression, or you can't get any credit for any increased disability. That's a compensable consequence. One follows the other. Now, if you're at work and you get stressed out, yeah, you could still collect on that, or not collect, or have an injury, as I said last time, arising out of work.
You're saying now you can't, because that would be a psychiatric claim.
It would be a psychiatric claim with the physical first. A reaction to the physical, if your psychiatric is a reaction to the physical, which comes first, as of today, you may not have a valid claim psychiatrically, which to me is ridiculous. Am I prejudiced? Of course I am.
But if you just have something psychiatric, you can still claim that.
Yeah, that doesn't make sense, because that can be much less than the terrible physical injury which rendered this guy, let's say, a cripple. But there's a couple exceptions, but it was all done for political reasons. I don't want to get into all of it, but it was some exchange done with their unions, and But as you know, what else is new? Psychiatry is the whipping boy, right? We're blamed for the Newtown, Connecticut shootout, right? Shooting. I mean, it's the guns, and the mental health guys don't know what they're doing. But the guy today, was he on trial? Holmes in Colorado, preliminary hearing. The guy that's shooting up the movie theater. It's not our fault as mental health people. It's the laws have gotten it's so difficult. But guns, yeah, you can't. But it still takes a crazy person with a gun to cause a problem. But yeah, that's where the law is. And they also said, because there's very enterprising attorneys out there, and we discussed GAF last time, remember? A lot of enterprising attorneys figured they'd pad the GAF, which is very inaccurate, but anyway, they would use the GAF. And then they would add sexual dysfunction. I don't know how you figure that, by impairment. And then they would add insomnia, if there was a sleep disturbance. And guess what? Compensable consequences of psych and all sexual dysfunction and sleep impairment in workers' comp, as of last week, no longer exist in this state. I know there's some political dealings going on. I'm not even going to theorize what was happening. But it was, let's just say it wasn't going to get through, but with pressure from the governor, Brown, he pushed it through. And it did get through. So these are good questions, and let's see what happens. I think there's going to be a lot of problems, a lot of litigation. But in the meantime, at this point, and I know a lot of attorneys have their own, going to deal with it, using their common sense and intelligence. Now, this is what I taught. This is, again, getting back to the power case, though, and this is what I like. And by the way, just as I said when I was here a month and a half ago, AME is a good spot to be in workers' comp. Because I went to this program, I was able to be AME from day one. Because, you always want to try to tell the truth. You don't want to shade it. You know that no matter what opinion you give, if you go to criminal court in a serious felony, say somebody's insane or sane or whatever your opinion may be, dangerous, not dangerous, you got to be ready for tough cross-examination, right? And that's really what an AME is. You just have to call it the way you see it. And I was fortunate that, I got situated that way, and I trained here. I didn't learn any workers' comp here, but I learned to call it the way I saw it. And this case here, the power case, has never been, oh, by the way, and I know none of you are attorneys, right? If a Court of Appeals case, by the way, what happens, I'm just going to ask this just generally. If a Court of Appeals case, and I don't even know how many districts we have now, maybe 5 or 6 appellate districts, what if it is appealed to the Supreme Court and the California Supreme Court refuses to hear it? What then happens to that opinion? It comes state law. It's assumed to be, it's like the Supreme Court's like them arguing, accepting the case and then saying, okay, we agree with it. Here they just refuse to hear it, but that's the law now. So this is the law in this Power case. And just remember, Power is a good name because that's the power of the work of the AME. And that's why it's a good position to be in. And it says in here, this was an interesting case to read about too. The judge declined to follow the AME, the Agreed Medical Evaluator, in this case. He declined. And the Court of Appeals reversed it for these words right here. And it says, the AME's opinion should be followed unless there is good reason to find his opinion unpersuasive. And he's chosen because of his expertise, which of course you have to know what's going on. That's why I wonder about this guy who's in his residency. He's probably not an AME though either. And neutrality. You're right in the middle. You know, whatever comes in the door, comes in the door. I don't have any prior agenda. When I'm an AME, I have no prior agenda. Am I working for Liberty Mutual or working for his good friend Joe Smith, who's the Gary Jones, who's the attorney? Well, thank you for the referral, but I have to call it the way I see it. And sometimes it's tough to do. When you see somebody in front of you who needs a lot of help in certain areas, but it's not work related, you have to say that. And I quote, I say you just to let the chips fall where they may. Do I get threats or problems later on? The answer is yes. Sometimes, not serious, thank God. But anyway, that's the Power case, and that's what it stands for. And I'll give that one out here. I'm missing the first page. You know how printers sometimes a little bit balky. So anyway, this was this case here, and this judge got reversed because he didn't follow the AME, and he started giving his own reasons for following one side or the other. He didn't satisfy the Court of Appeals. So that's the law now in this state, and it's been the law for 27 years, right? Since 25 years, since 86. 27 years, 86. And that's it. It's like a Supreme Court decision because the Supreme Court wouldn't hear it. They refused to hear it, and that's now the law in this state. So that's a good situation to be in. And when you talk to your associate, ask him if he's an AME. Probably, well, not if he's a resident. Couldn't be.
Well, now he's done and still does it.
Did he like workers' comp?
I think so.
Yeah, it is interesting. I mean, is it sexy, or I shouldn't use the word sexy, but is it as interesting as mass murderers and all kinds of nasty stuff? Probably not, but I mean, there's a lot more. There's many around. What were the stats I gave last time? About 1 million work injuries a year in California. That's a lot, and a lot of these guys have psych add-ons. So let's see, how are we doing here for pages, Roberto? I'm up to page 20. Yeah, let's see the next one here. Okay, section 2. Why don't we take a break for a couple minutes? Is that okay for a couple minutes? I'll just have a drink of water. And I like all the questions, though. They're good. And the next half will be interesting issues coming up.